Hello, good morning, and welcome to 10 Tips for Client Trust Accounting Compliance, what every Californian needs to know. I'm delighted to introduce our speaker today, Christine Rosskopf. Christine Rosskopf brings nearly 3 decades of experience as senior counsel at Rosing, Pott, and Strohbehn. Ms. Rosskopf's practice focuses on professional liability, ethics, and risk management law. Ms. Rosskopf was previously trial counsel at the State Bar of California. Now let's get started.
Good morning. Welcome, everyone, and thank you for the introduction. You are in 10 facts about client trust accounting. And as was mentioned in the introduction, I currently do ethics defense work for the State Bar, both for attorneys before the State Bar and judges before the Commission on Judicial Performance. I also assist sort of on an on-call basis attorneys and law firms with ethics questions. And formerly I was a prosecutor for the State Bar, so I've been on both sides of these issues. So let's get started. So why client trust accounting and why 10 facts? I created this program. It's a very basic 10 basic facts about client trust accounting. And I felt that there was a need to get this basic because I found when I was both at the State Bar and in advising clients that people get some of the real basics wrong, and that's no fault of theirs. I think a lot of people approach client trust accounting as, I'm an honest person. I have no intent of stealing clients' money. I want to handle it appropriately and carefully, and they just approach it very logically. And unfortunately, some of the client trust accounting rules aren't particularly logical. They don't things that you think would be okay, well, that makes perfect sense, end up being violations when it comes to client trust accounting. So I thought it would be a good just let's get back to basics and get down to some basic facts. So why should we care? Why is this so important? As you can see in your materials, client trust account violations are some of the easiest violations for the State Bar prosecutors to prove. They are also come with some of the most severe discipline when there are violations. Even first-time offenders can be given long suspensions or even disbarments when they are found to have mishandled client funds. I've added a couple of State Bar cases if in the materials, if you're interested in reading them, where what seems like not innocent activity, but not super severe, would seem to be super severe activity, resulted in really severe consequences for attorneys. I added the State Bar cases because I'm aware people who don't do State Bar work have a little bit of difficulty locating State Bar materials. State Bar Court has its own court, obviously. It has its own court reporter. Although the reporter is available on the State Bar Court's website, it can be difficult to locate, and doing research in State Bar Court cases can be cumbersome for people who aren't familiar. So those are in your materials if you're interested in reading them. So let's get into the facts. Fact number one, there is a client trust account mandate. If you hold any funds for a client's benefit, you are required to hold that in a trust account. That's mandatory. That's the rule of professional conduct 1.15. And rule 1.15, it's a very long rule. I've included it in your materials. It really lays out for you all of the rules about client trust accounting that you're going to need to know. What's included in client funds? Obvious ones are cost retainers, fee deposits, settlement proceeds. What about other assets? If you're a family law attorney and your client sells the family residence, they may ask you to hold those proceeds for them in trust, pending an ultimate distribution of assets. If you are doing plaintiff's work and you've got someone who perhaps is a minor and receives a large settlement, sometimes the attorney will be asked to hold the settlement proceeds in trust until the minor reaches the age of majority, those sorts of situations. You are required to hold those funds in trust. You can't just put them in your business operating account. Sometimes you're also asked to hold other property in trust. That would be things like jewelry, art, manuscripts, firearms. You can be asked to hold all sorts of things for a client. If you find yourself in that situation, you don't just throw it into a desk drawer. You make a written record of not just what you received, but how you received it, the date, the time, whether it was hand delivered, whether you received it in the mail, through a messenger, as much detail as possible. Describe the item, label it with the client's, identifying the client's name, the client's account number, any other information that might be necessary, and you put it somewhere safe. That doesn't mean a desk drawer. That can be a bank safe deposit box. It can be a safe in your office. It can be a locked cabinet. Just don't put it somewhere where it is openly available to other people. That is the first fact. That there is a mandate about holding things in trust for a client. Fact number two, you need to choose your account type. There are actually two different types of client trust accounts, and I want to get the nomenclature here clear. And this is just me being a former prosecutor. People get the names of the accounts mixed up a lot. Client trust account is the general term for any account in which you are holding client funds. Under that umbrella of a client trust account, there are two. There's the dedicated account and the IOLTA. All IOLTAs are client trust accounts, but not all client trust accounts are IOLTAs. Let me do the dedicated accounts first. They're less common, but they can trip people up, maybe because they are less common. The dedicated accounts are used for either a single client, or a single matter, a single asset. The account must be interest-bearing. The interest goes to the client. The account name must clearly indicate that it's a trust account. And the financial institution, and this is very important, the financial institution needs to link the account to the client's, not the attorney's, either social security number or tax ID number. I've seen this happen. An attorney was asked to hold funds that was, at issue in a transaction. He put it into certificates of deposit. He did segregate it because it was a large amount. It was going to be held for quite a while. And he thought it would be helpful for the client to put it into a certificate of deposit because it was going to earn higher interest than a regular savings account. He initially the bank put his name on it. He did catch that quickly and had them change it, which they did. Unfortunately, the bank linked the tax ID number to his business account, not to the client's. And what happened, of course, at the end of the year, when the interest, which was supposed to go to the client, and actually did technically go to the client, in tax forms was reported as his earned interest, and it created a mess that he needed to unwind and deal with. So be very careful when you're setting these up, that it is set up truly as the client's tax ID number, not yours. The other type of account is the one that everyone's more familiar with, the IOLTA. IOLTA is an acronym. It stands for Interest on Lawyers' Trust Accounts. The IOLTA is an aggregated account. You hold funds from multiple clients into a single account, and the hallmark of this type of account is that the interest earned on those funds goes to the State Bar of California. Does not go to the clients, and God forbid it doesn't go to you. It is reported to it's at the end of the month. The bank automatically transfers all interest earned for that month to the State Bar of California. The State Bar of California earmarks those funds for programs related to access to justice. This is not considered a taking. It's not unconstitutional. It's been tested, and it is constitutionally permitted. It's a program that's been going on for quite a long time. Notwithstanding how long this program has been in effect, I've actually had a client who had an old aggregated trust account that was not an IOLTA. It wasn't set up as an IOLTA, and the interest was actually going to the client. It wasn't going to the state bar. It created problems. Um, when you think of an IOLTA, I would like you to get a picture in your mind of a bunch of small savings accounts, each one with a client's name on it. And they're all just huddled together in this one room. And each of these accounts is inside this larger IOLTA account called the IOLTA room. That will be helpful later when we're talking about misappropriations and balancing the accounts. Um, which account to choose? Sometimes people have questions. Okay, do I put this in an IOLTA or do I put this into a dedicated client account? The general rule is if administration costs exceed potential interest for the client, use the IOLTA. I've cited a case here where this was the conversation. Generally, if it's going to cost more to administer a dedicated client account, so if the bank charges are going to be higher and just administrative costs generally are going to be more than the account earns, then generally it's okay to keep it in the IOLTA. Keep in mind, there are going to be situations where even if it's a little bit more expensive or more cumbersome, the client's going to request that they have a dedicated account for their funds. And you should work to honor that request and not put it in the IOLTA in those situations. Um, all client trust accounts must be maintained in California unless there is a substantial relationship between the client or their business and the other jurisdiction where the funds are held. This rarely comes up. I don't know that I've ever had a situation where someone was holding the funds in a non-California account. Usually the question is it okay to use a credit union? Is it okay to use a national bank or does it need to be a local bank? As far as the national banks go, as long as they've got a local branch and the funds are quote unquote managed by the local branch, that's okay. The credit unions usually are also okay. The State Bar of California maintains a list of what they call IOLTA eligible accounts. If you have any question about whether or not a bank that you're planning to do business with it does have an IOLTA eligible status, you can ask the State Bar. I've put the who to contact in your materials. Banking compliance at calbar.ca.gov. What constitutes an IOLTA eligible bank? I can tell you generally the banks that are IOLTA eligible have agreed to certain compliance issues. One is, of course, the transfer of that interest to that state bar dedicated account. They've agreed to do that. They also agree to comply with the rules relating to bank reports, which we'll get to later. But basically, they agree to notify the State Bar of California of certain activity in the IOLTA account. So those are pretty much the basics. There are also some interest related, like level of interest related issues with the IOLTA eligible accounts. Generally speaking, any bank that you're planning to deal with, most credit unions are all going to be IOLTA eligible, and it shouldn't be a problem. Of course, we're all aware, and this is a whole nother MCLE program. There is a CTAP compliance required. It's going to be required at the end of March this year. You are supposed to report all client trust accounts. That's both IOLTA and non-IOLTA. So if you've got dedicated client trust accounts, those two are supposed to be reported to the State Bar annually. There's actually another rule somewhere that says within 30 days of the creation of the account, or if there's a change to the account, if it's closed, it's supposed to be 30 days. But there is sort of this catch-all that you should, there's a California rule of court 9.85 that says at least annually you are supposed to update the state bar on your client trust accounts. And that is covered these days by your CTAP compliance. Next fact, the danger is danger in commingling. The whole point of commingling, the concept is you should never be mixing personal funds with client funds. Think of them as opposite magnets that repel one another. They really should never be held in a client trust account together. There is one very small exception. That is, you may maintain a cushion amount in your client trust account, whether it's an IOLTA or a dedicated client account, to cover bank fees. That can be your own business, your own money or your business's money. That is truly a relatively de minimis amount. We're talking $10, $20 a month. We are not talking, as I had one client do, keep $20,000 in that account as a cushion because he wanted the assurance that he was never going to bounce a check out of that account. That's too much. The account, you cannot hold your own funds in the account. The reason for that is the account, the client trust accounts, because they're trust accounts, they are protected from your creditors because they're not your assets. The trust accounts are considered the client's assets, not yours. They're not assets of your firm. I did have an attorney who, when applying for a line of credit for his business, on the application listed the client trust account as an asset. And of course, the client trust account had a fairly significant balance because there were settlement funds and retainer funds in there. The attorney obtained the line of credit and uh, was defaulted on his payments, and the lender then turned around and pulled money electronically out of the client trust account. It was an IOLTA, out of the IOLTA for payment of its line of credit, triggering obviously a bunch of bounced checks, a bunch of bank reports, and some serious discipline for the attorney. So, and it all went back to that basic idea that you shouldn't have put this account on your list of assets because it's not your asset. You know, the state bar gets very upset if you've got your own funds in an account, you're holding your own funds in an account like that. And for instance, you may be going through a divorce, or you may be having creditor issues, or, you know, the tax authorities are looking for funds, and you've parked $20,000 or more into an IOLTA. There are going to be consequences for that. Also regarding commingling, um, these are mistakes I see a lot. Mistakes do happen, and what you really want to do is make sure that you've taken some precautions. Make sure that the deposit slips for your IOLTA look different than they do for your regular business operating account. Make sure the checks are a different color. You know, if you've got red checks for your IOLTA or your client trust accounts, and you have green checks for your business operating accounts, give yourself that extra little visual because mistakes do happen. People grab the wrong checkbook, they grab the wrong deposit slip, and then you've got a situation. One other trap for the unwary, a lot of banks just automatically issue debit cards for any of their accounts. If you have received a debit card for your client trust account, whether it's a dedicated account or an IOLTA, don't use a debit card on that account. You're just asking for problems. You don't have the paper trail that you need with traditional deposit and withdrawal slips. You're going to be walking around with a debit card in your pocket, and grab the wrong card and pull money out for something that's personal. I have seen attorneys pay for gasoline, pay for groceries out of the client trust account because they were using a debit card inadvertently, and it created all sorts of problems. So just take some precautions up front. Next fact, the overdraft red flag for misappropriation. One of the hallmarks of an IOLTA eligible account is that they will report to the state bar when there is an overdraft on the account. It's an automatic bank report. And it does not matter whether the overdraft was honored or not. Say you've got a check that has insufficient funds. Sometimes, if you've got a great relationship with your bank, they'll go ahead and pay the check. They'll honor the check. They won't bounce it. But then they'll, of course, put the bank account into the negative because they paid the check, they honored the check. Alternatively, they may bounce the check, in which case you're like, well, there was never a negative balance, it was bounced. They'll still report those to the state bar. They get reported directly to the Office of Chief Trial Counsel, which is the discipline arm of the state bar. Depending on the amount, other than the most de minimis and the first time it happens, if it's anything more than literally just a few dollars, it's going to trigger a state bar investigation. Now, you may not even be aware that there's a state bar investigation. You may not even be aware that this happened. Hopefully, you'll know at least by the end of the month. If not sooner, you'll get a notice from the bank. But at least at the end of the month, when you're doing your reconciliation, you'll discover this. But you may not be aware that the state bar is investigating. And depending on the amount, the state bar may actually even issue a subpoena to your bank to get records for your client trust account. And you may not even be aware that any of this is happening. So be aware that that is something that happens. If you are aware that there has been an overdraft, keep an eye on your email for a message from the state bar because you're very likely to get one. The reason the state bar is so keen on finding out quickly whether or not a client trust account has gone into the red or has had any sort of an overdraft, even if it's cured quickly, is because it's a red flag for misappropriation. We'll get to misappropriation in a moment. But misappropriation is the theft or taking of client funds. It's probably one of the most serious ethical violations someone can make as far as the state bar is concerned. It is taken incredibly seriously for obvious reasons. It undermines public confidence in the legal profession, and when found, misappropriation merits some of the most severe discipline that the state bar can met out. Next fact, balance dip. If a client trust account is being managed properly, there should never be a reason for the account balance to fall below the total amount owed to all clients, meaning the amount owed, meaning the amount being held for the benefit of all clients. This gets back to my little visual of individual accounts, right? So if you've got a bunch of client funds, you can't sort of, even though it is held as an aggregate, you still have to think of it in terms of individual accounts for each client. And the reason for this is you can't borrow from one client to pay for another client. And I'll show you where this happens frequently. You have a settlement check coming in, your client's very excited about the settlement. They want the funds immediately. And you're figuring, well, I have got plenty of funds in the client trust account to cover, and I will just write the check because I know that when the settlement funds come in, or either when the check clears, it'll all be fine. It'll all come out in the end. That's technically a balance dip because you have technically used a different client's funds to write that check to the client because their funds haven't cleared yet. And that is considered a misappropriation. It happens more frequently than you think. So what you need to do, it's a good idea to manage client expectations at the front end and let them know that they are going to, when settlement funds come in, there's going to be a delay until those funds actually clear and are available. If you've been working with your bank, you generally know whether it's a 5-day hold, sometimes a 10-day hold. You need to manage your clients' expectations and make them aware of that. And it's very tempting to want, everybody's excited. You want to write the check and say, here you go. We know you've been waiting for this. Don't use other clients' funds to pay one of your clients. Let's see. What about overdraft protection? Overdraft protection is, when a bank offers a program that is designed to assist you in the event that there is an inadvertent overdraft on your account. It's just technically it's considered a loan, and the programs take two forms. They will either, in the event of an overdraft, transfer an amount equal to the amount of the overdraft into your account, and then basically you're required to pay that back, or they will transfer funds in increments, whether it's $100, $500 increments, whenever there's an overdraft. There is actually an ethics opinion on this. It's Corpac Opinion 2005-169. It's in your materials. Um, if the bank has the former, where it's the amount transferred is exactly the amount of the overdraft, it's not considered commingling. If, however, the bank has a program where they transfer increments, then technically the amount of the quote unquote loan that they're giving you, those are your funds that you've borrowed. And then if they've put it into the IOLTA as part of their program, you have now your own funds commingled with client funds in that trust account. The second one is a commingling. The first one is allowed. Frankly, if you are managing your client trust account carefully, there really should be honestly no reason to overdraft. Although I understand mistakes do happen, it's probably a good idea not to have overdraft protection. If you want it and want to take advantage of it just in case there's a mistake or an error, just make sure you understand your bank's program and how it works. Otherwise, you're going to get yourself into trouble when logically you're trying to do something that simply makes sense, right? Next fact, transparency and subpoenas. I mentioned earlier that when the State Bar gets a bank report, they may issue a subpoena. When you became a member of the bar, you automatically agreed to allow the State Bar of California access to any client trust account you are holding. They don't need to ask your permission. They don't need to have good cause. They don't even need to tell you they're doing it. They can issue a subpoena for any client trust account that they are aware of that you've reported, and access those bank records. They will not necessarily tell you that they are issuing the subpoena. They're supposed to tell you once they've received the records. They will tell you that they have received bank records, but they do not tell you in advance. That is for the client trust account only, for the dedicated accounts as well as the IOLTAs. You've already given them that permission, although you may not have known it. Contrast that to your business operating account. If after reviewing your client trust account, the State Bar has questions about maybe transfers that have gone back and forth, and they want to see the records for the bank operating account, they can subpoena those. However, they need to show good cause. And I can tell you that that's a very low threshold when you're talking about a regulatory agency and potential mishandling of client funds. So that's a pretty easy bar. But they do, in the case of your business operating account, they are required to give you advance notice. So you do have an opportunity to object. I can tell you, unless it's very unusual circumstances, an objection is not necessary, is rarely ever going to be successful. The State Bar has rather strong powers as far as monitoring client trust accounts. Obviously, this is an important issue for them, more so even now, recently, than it has been in the past, and they are very aggressive when they are investigating any potential client trust account issues. So just be aware that they will be asking not just for bank statements, they will get signature cards, they will ask for deposit slips, canceled checks, wire transfer information. They will get all of that, especially with the canceled checks. They can get a lot of information about the memo lines and the endorsements off the back of those canceled checks. Those are the documents they're going to be looking at. They will not give you a copy if you ask for it. Usually, they may as a courtesy, but I have on occasion asked for copies and they've said no, you should have these anyway. And so you have to, if you don't have them yourself, you have to go back to the bank. The standard for most investigators, they'll get 3 months. When I was at the state bar and I was working with investigators, I used to ask them to get 6 months just because it happened so frequently that I get three, and three just wasn't enough to be able to track some money that had come in. The money had come in before then, so I used to ask them for six, but it's usually 3 months that they'll get, at least at the beginning. Um, okay. Timeline for funds. These are new rules as of January 1st of 2023. I think people should be more aware of them now. Once you receive funds on behalf of a client, it used to be that you needed to notify the client promptly. And I'll get to this, but it's not just the client, anyone with an interest in those funds. So the client and any lien holders. The rules changed. This is Rule 1.15D1, which is in your materials. It's now 14 days. So when you get funds in, you have 14 days to notify the client if there are medical lien holders, if they've got perhaps a litigation funding lender who has a lien on any funds coming in, if there's a prior attorney that has a charging lien. All of them need to be notified that the funds, you've received funds on behalf of this client. The rule technically does not say, I don't believe it says in writing, but obviously anytime you're dealing with anything along these lines, do it in writing, even if it's just an email, but do it in writing so you have proof that you complied with this requirement. Likewise, we now have clarification on the timelines for distribution of client funds. It used to, again, be promptly. It is now 45 days for undisputed funds. So what are undisputed funds? Undisputed funds are funds where the ownership interest is fixed. This trips people up and it results in a lot of questions. So say you've got a settlement that has come in, personal injury settlement, it's $100,000. And your fee is 40%. And then you have a prior attorney with a charging lien. You've already worked out with that prior attorney that you're going to split 50-50. So as soon as the money comes in, the attorney's fees portion, the 40% of that, is fixed. There shouldn't be any dispute about that. You should pull out that money within the first 45 days and distribute it to yourself and to your other, to the prior attorney with the charging lien 50-50. That is undisputed. The remainder 60,000, say there is a medical lien. The amount of the medical lien right now, I'm gonna have to write this down so I don't screw up my math. The amount of the medical lien is 40,000, but that's the maximum amount. You haven't negotiated down that lien yet, but you know it's at least 40,000. And you know it's going to take maybe a couple of months to negotiate that. So it's not a fixed amount. But you do know that 20%, the 20,000 left over, is undisputed, and that should go to the client. So within the 45 days, you should distribute the 20,000 that's undisputed to the client, hold back the 40 while you negotiate the medical lien. Once the medical lien is negotiated, say you do an amazing job, you negotiate it down to 10,000, you distribute the 10,000 to the medical lien holder and the remaining 30,000 to the client, because that's now undisputed and everyone's got their full amounts. Obviously, you prepare a written accounting to the client, a final accounting that lists everything, all the money that came in, all the money that went out, and where it all went. Those are, if you've got any questions about that, I get a lot of questions about when funds can be released, when they need to be held. Definitely either look at the rules. I'll give you some resources at the end of the program that would also be helpful. Call counsel, or you call the ethics hotline at the state bar. They may be able to help you if you've got any questions. But that's where a lot of people get tripped up is how long to hold things, when to hold things. Now, if your client says, I don't want piecemeal checks, I want to check one time, maybe it's the end of the year, they're trying to, when the funds come in. If they want you to hold the funds longer than 45 days, you can hold the funds longer than 45 days, but get it in writing. Always get it in writing, to cover yourself, so that you can say, I'm holding these for a reason. I had one client, whose client received a large settlement, and she was concerned that she was going to spend it all at once and wanted it sort of distributed, um, periodically. And so my client, unfortunately, this was just an agreement they had and didn't get it in writing, and there were issues later. What my client should have done, it's okay to do that. What my client should have done was get in writing from the client, I want you to continue holding this. Please continue holding these funds for me. In that case, it would have been fine, and my client could have distributed it per the client's request without having problems. You can never assume that there isn't going to be some dispute down the road, even if everyone's getting along fine at the beginning. At the beginning. So that's fact number 7. Oh, the other thing, there are sometimes questions about the charging liens, meaning if there's multiple attorneys and you've got a prior counsel and there's a dispute over the split on the attorney's fees. There is a recent ethics opinion that's helpful because we needed some guidance on this. It came out from the LA County Bar Association's Professional Responsibility and Ethics Committee. It's opinion number 534. I think it came out in October or November of last year, and I included it in your materials. So if you find yourself in that situation, if that's something that is familiar in your practice, you may want to take a look at that. It gives you some guidelines. Fact number 8, required record keeping. Okay, there are 3 records that the State Bar requires you maintain relating to your client trust account. And I can tell you, virtually no one does this correctly. So after today, you're going to do this correctly. The 3 records are your client ledger, your trust account journal, and your monthly and proof of your monthly reconciliation. Okay, the client ledger, if you go back to that visual in the IOLTA, you've got a bunch of smaller, separate client accounts. Each of those individual savings accounts needs to have its own ledger, just like a bank ledger, money coming in, money coming out, plus, minus, back and forth. Every client for whom you are holding funds, you are required to maintain an individual client ledger. It tracks every transaction per client, costs that are spent on behalf of that particular client, funds that have come in for that client. You need to maintain this both for an IOLTA, for each client whose money is being held in an IOLTA, but also maintain it for the dedicated client account. Think of it as the record of each client's little savings account, and you're going to have a bunch of them. Depending on how many clients you have, you've got 20 clients, you'll have at least 20 client ledgers. Okay, the next document is a trust account journal. This is a master record of all bank activity. If you use a program like Quicken, I think Clio has one, they all have an overall journal of all bank activity that goes in and out of your trust accounts. And that record needs to be maintained separately from individual ledgers. Getting back to the ledger, I have had clients who don't keep separate ledgers, but they use their invoices, because on their invoice, they'll have a running total for the client of expenses in and out. It's not a great way to do it. When faced with State Bar inquiry, I can argue that, okay, this suffices, but that's not really best practices. So we covered the ledger, we covered the journal. Then the third item, which is the one that most people don't maintain. That's the monthly reconciliation. The monthly reconciliation is a comparison of all your client trust account ledgers and your trust account journal to the bank statement that you're going to receive every month. And you need to balance it all and make sure that everything balances out and everything is accurate. This is when you're supposed to, on a month-to-month basis, catch any mistakes that may have occurred, and this is your opportunity to correct them. But where people trip up is they don't do this monthly. And if they do look at it, they don't keep a written record proving that it was done. So you need to have it in writing, prove that you did it. This will account for checks that haven't, you should be accounting here for checks that haven't yet cleared. This is where you should catch, say you wrote a check to a client or a medical lien holder and it hasn't cleared. And if you see that for running for a couple of months, follow up with the client, follow up with the lien holder before they make a complaint to the state bar saying, this attorney owes me money and was supposed to have sent me money and never did. You can catch that mistake in advance and save yourself a lot of headaches. In the materials, at the end, I have a monthly client trust account checklist, and it goes through each step as to how you should do these reconciliations. It's at the end of the materials that you got today. There are basically 3 steps. You reconcile the journal, you reconcile the ledgers, you do a final audit, you total everything, the total of all the client ledgers, and the adjusted journal balance, which is accounting for checks that haven't cleared yet, right, should equal the bank balance. So make sure that that happens. Make sure you do that monthly and make sure you have a written record that you did it. Okay. Fact number 9, the 5-year audit trail. State bar discipline cases can go back 5 years. There are some new nuances that potentially make it 7, but the rule is that for the accounting records, you are required to keep them a minimum of 5 years. Do yourself a favor, keep everything for 5 years, keep it organized. So if there are inquiries, you can show and prove that you did what you were supposed to do. My last fact for the day is that there are state bar resources available to you. The state bar, when I was with the state bar, we used to offer these, the trial counsels were the ones who, we would divvy them up it was given, an ethics school and a CTA school was offered once a month. And we would teach them ourselves. We would team up. And it was incredibly helpful because it's sort of real life stuff. They will tell you, oh, this is what happens. This is what I commonly see. These are the violations that occur. This is how I would address X, Y, or Z. Would I charge this if it were a standalone? Probably not. Would I charge it if it were, combined with other violations? Absolutely. So it was very helpful. I believe they have changed it now. I haven't had an opportunity to take it recently. I believe it may be it may not be a live presentation anymore, but it is still offered. It is offered more frequently now, and it's offered online. You can go on the State Bar website and find e-learning, and you can take it through there. If you are required to take CTA school, which is sometimes a requirement as part of discipline, you don't get MCLE credit for it. If, however, you take it, not because it's required, but just because you're interested, and I strongly advise that you do get MCLE credit for it. I did look on their website, and it's a little bit confusing. You need to make sure you sign up through the alternative enrollment tab. The alternative enrollment, it's the same course, but it's for the people who are taking it voluntarily. If you do the regular, I don't remember what it was called, the general enrollment, that is for people who are required to take it and aren't getting credit. So make sure you sign up correctly through the correct path so that you actually get credit for it. Um, Included in the resources offered by the State Bar and included in that course, they go through all of the trust accounting. They have a client handbook of client trust accounting, which is online. It's available online regardless of whether or not you take their course. I would strongly recommend that you download that and look through it. And as just as an aside, just because I've seen where people run into trouble, if you are having someone else do your accounting for you, frequently, it's a non-delegable duty. So although you aren't necessarily required to do the bookkeeping for your firm and for your clients yourself, you can delegate that to somebody. You're ultimately on the hook for whatever happens. And I've seen a lot of people run into trouble because they start out with a small firm or solo, and the practice just starts growing, which is wonderful. But some things don't always keep up. And sometimes one of the things that doesn't keep up is the bookkeeping and having someone who knows what they're doing the bookkeeping. So sometimes it'll be, your receptionist is also, well, she's just sitting there, let's let her do the bookkeeping as well. Or it can be an assistant or a spouse that will come in. If they haven't been trained specifically in law firm accounting, even if they've got some background in accounting, make sure that you invest in your people, that they are properly trained so that they know what they're doing. Again, this goes back to that whole idea. Things aren't always logical when it comes to state bar compliance and client trust accounting. So they may do something that they think makes sense. Well, I'm just going to hold all of these funds until, we can write one check to the client. Or what's the problem with giving the client the settlement funds today? We know the check's good and we know it's going to clear, and there's funds in there from this other thing that we have where we're holding all this money. So there's plenty of money in that account. Why not just write the check to the client? They don't know these things, and the average person wouldn't. So you do need to make sure that the person you're relying on knows what they're doing, has been trained, and make sure that that training gets updated periodically. So invest in that. Also, although I know it's not practical necessarily, the expectation is that you personally are going to check that monthly reconciliation every month. And so whether or not you do, understand that you're going to be charged with that responsibility. So keep that in mind. Excuse me, and make sure that that's something that you do. So I see that we do have some questions. So I would like if we can now maybe get through some of the questions. I can answer them as they come in.
Alrighty, so starting off, Christina asks, if parties sell a home in a divorce and agree that the net proceeds be deposited into an IOLTA rather than an interest-bearing trust for a client, is that still a violation of state bar rules if the
No, not
stipulation
at
is signed?
Not at all. As long as it's held in trust, that's fine. Unfortunately, the clients who are agreeing to that need to be aware they're going to lose the interest. They're not going to get the interest on that amount, that the interest is going to go to the state bar. If they're okay with that, just make sure you get it in writing. As long as you hold it in trust and, they've agreed, then that's fine.
All right, thank you. And Cynthia asks, is it a violation for a client to agree to a Is it a violation her client agrees to a Zelle, an initial retainer payment into the general operating account, and then funds are transferred to an IOLTA due to the inability to set up the Zelle account directly linked with
Yeah,
IOLTA?
yeah. So here's the deal. This happens all the time. You can't, as the person who's asking the question, Cynthia, points out, you can't link Zelle or any of the other Venmo to an IOLTA. That's just asking for all kinds of problems because they can go in and get money, they can get access. So what you end up doing is if you're going to take payment that way, it goes to the operating account. What I would do is move it quickly if you know the money is coming in at a minimum weekly. I would any money that has come into the operating account that way, if not daily, transfer it immediately. Um, make sure you have a paper trail that you've done it that way. You're not going to get charged with that. That's I guess technically it's a violation. This is something that we talk about in the CTAs. We used to talk about in the CTA school all the time. Is it a technical violation? Technically, yeah, but it's a practical matter how else you're going to do it, right? So as long as you do it quickly, don't hold it there for any inordinate amount of time, and make sure you have a paper trail, it's fine. You're not going to get in trouble for doing that. People, as a practical matter, the rules don't always catch up to what is, in practice and what the current ability is. So now we've got Zells. You got the same issues for people who are taking payments via credit cards. Just make sure that if you are using those forms that you document, and move it quickly to the correct account. You should be fine.
Great, thank you.
Mhm.
And Andrea Miller asks, we had a $15,000 client check returned. It did not overdraw the account. Would this still initiate a report to the state bar?
No. If the client's check got returned, no. It's only if a check that was written on the IOLTA account gets returned that's going to be reported. Now, obviously, that is something you're going to want to be aware of, and hopefully you catch that if in your monthly reconciliation, if not sooner, so that it doesn't cause problems. Thinking, okay, you didn't realize the check was returned. You thought the client, according to their ledger, had that 15,000 and you paid for a court reporter or something, and then you overdrew your IOLTA account. That would be a problem. And that would be something that would trigger a bank report. But under the circumstances you said where it was just the client check, no, that's not going to trigger the report.
Great, thank you. And Cynthia has another question. Does the notification to the client and lien holders apply to initial retainer deposits made by the client?
No, because the client obviously is aware that they gave you the funds, so they're already aware of it. And I'm I'm not aware of any situation where you would already have lien holders before the client even retains you. Um, that would be I mean, I guess if you have some odd situation, if you have some odd situation where there's I don't see where you need to, no. Sorry. No, because the client, you don't need to tell the client that they just gave you money, right? So I wouldn't worry about it. And if there's a lien holder where the client just retained you, um, yeah, I probably wouldn't notify the lien holder either that the client had paid a retainer. That's yeah, I wouldn't notify anybody of that.
All right, and Joshua asks, what if we are considering reducing our PI contingency fee pending the outcome of the medical lien reductions? Should we still take our full fee out and then if we work out a deal later, send money to the client out of our operating account?
Um, It depends if you're considering giving them, say they're upside down and you want to help them out and you want them to get something out of the litigation, and so you're considering reducing your fee. Um, you can do it either. You can do it either way. The best way to do it would be to um, take the full fee, and then again, as if you want to provide them a discount, you can funnel it through your operating account back into their account as a discount. However, if you can just say, maybe make a notation um, in your records that you are considering you're not taking your full fee because you're considering a discount, then you can probably leave it in. It's probably going to be fine. What you might want to do in that situation, although this can get cumbersome from an accounting perspective, say you're like, well, we routinely offer, when we have situations like that where the client gets upside down on medical liens or whatever. Um, and so we want to give them a break on our contingency. If you know that the standard that you do is you reduce your contingency from, 40 to 35% or 40 to 30%, something like that, maybe take the 30 or the 35 that you know you're going to keep and leave the remainder of it until you determine whether or not you're going to give them the discount. But I think as long as you document it, you're probably going to be okay.
Alrighty, thank you. And Kenneth Hune here, it looks like he has a hypothetical question.
Oh dear.
Assume you have a settlement for X amount of dollars. You deposit the check into your IOLTA. You distribute the money to the client and you distribute the money to yourself per the agreement. But you
Mhm.
make a mistake and you distribute X plus $20. You discover this later after reconciling ledgers. What should you do?
That is the point of the reconciliation. It depends on who got the extra 20. Now, did you take extra 20 over and above what the settlement amount came in? Or did you just mistakenly give one person 20% that belonged to the other person, right? First thing you do is correct it and make sure that the person who got shorted the 20 gets their 20. And the person who got 20 too much, you try and get it back. Um, if technically, if you took more than the settlement amount, more than X, so if it was X plus 20 total, um, technically you've misappropriated from another client. That's where we get back to these are individual savings accounts, right? So if there was it happens when there's a clerical error. That's why you do the monthly reconciliation. That's the purpose of the monthly reconciliation is to catch those errors and correct them. I think if there's simply a clerical error, particularly for such a small amount, but even if it's a larger amount, if it truly is a clerical error and you caught it on your monthly reconciliation and you fixed it, you should be fine. You may have to do some explaining, but you should be fine.
Great, thank you. And Lan is asking, I use bill pay to directly send checks from my bank to the client, so the money is gone once the check is cut. Is this a recommended practice?
To directly send checks from my bank to the client. So the money is gone once the check is cut. Is that a recommended practice? Yeah, I mean, it's no different than doing a transfer, an electronic transfer, right? That shouldn't be, yeah, that should be fine. Bill pay, yeah, because bill pay is, you're doing bill pay out of your IOLTA. It's just an electronic transfer, and that's fine. That's fine.
All right, thank you. And Norman Pine asks, how do associates in the firm who have no access to an IOLTA account report direct property or properly to the state bar CTE? Excuse me.
This is the CTAP compliance. It is truly its own MCLE program. There is something called agency billing. The state bar, in its infinite wisdom, always calls things, makes confusing names. The people in the firm who don't actually handle the money, there is, if you go through your CTAP compliance, there is a category for them. It asks, do you handle client funds or not? And if you don't, then you check that box. And if you are somewhat responsible for, like, say you do maybe have settlement checks come in that you have handled, but you don't actually do the accounting, you're an associate and there's an accounting department or an accountant, then the accountant, the firm can report for everyone in the firm. It's through agency billing. And that's what you're looking for is agency billing in that situation.
Great, thank you. And Patrice asks, how many days after the funds are earned do you have to wait before transferring out of the trust account?
You don't have to wait. Once they're earned, if they're truly earned, you can transfer them out immediately.
All right. And Joyce asks, is it okay to put client funds that will not be dispersed for a long time, typically probate funds, to deposit the beneficiary's money into a higher interest CD account for their benefit?
Yeah, see, I had a client do this. They used a CD and instead of a deposit account, and the reason was the higher interest. And I would argue yes, but be careful because this was the problem my client ran into. The bank, when creating the CD, created the CD in my client with my client's social security number. It wasn't even their, I don't even think it was their business tax ID number. I think it was their personal social security number. So the only thing you have to be aware of, I would make sure if there are beneficiaries that you want to make aware of this, maybe just in writing say this is what you plan to do and make sure they're okay with it. When you are doing sort of your algebra for whether or not this is the most, you're doing this for the benefit of the client, right? Is it going to be the best return on the money? Consider the any penalties for early withdrawal. Like, so when you're choosing your CDs, if any additional savings they earn because of a higher interest rate gets depleted because, the penalties for an early withdrawal on the CD are severe, so severe that it wipes out any interest. You may want to factor that in, but you should do that, set it up that it automatically renews and that the interest is reinvested, right? Just make sure that the client's aware of it. And I don't think there's any problem with it. I mean, I didn't think there was any problem with my client having chosen a CD rather than a more traditional deposit account. It was just that the way it got set up was problematic. So just maybe, even though it's for a long time, you maybe, discuss it with your client, what period of time, whether it's a 1 year, a 5 year CD type situation, you know, what they think is going to be most appropriate and how they want to handle it. There's a second question, I think, in there. Nope, never mind. This is the next Stevens.
Alrighty, so Stephen asks, if our firm loses contact with a client and multiple attempts are made over the course of a year or more to reestablish contact, mail, telephone, email, text, skip trace, etc., and client funds, balance from a lien negotiation, for example, cannot be sent to the client as a result, is the lawyer obligated to remit the funds to the state controller as unclaimed property? Secondly, if a client does not cash their check after substantial time or multiple checks, is it appropriate to send a cashier's check to the client?
As to the first question, it was much longer than a year, but I did advise the client that they needed to remit the funds to the state controller as unclaimed property and make sure that they kept their documentation of all their efforts to get in touch with the client. And I'm sorry, going back, what was the second question was, oh, can you send a cashier's check? If they haven't cashed, oh, I see what you're saying. So if they haven't cashed a check that you've written, and so that those funds are basically sitting, can you basically get the funds out of your account permanently by um, by basically voiding the uncashed check, or it becomes stale after a certain period of time, and then use those same funds to get a cashier's check, which once you send to them, the cashier's check was purchased and the funds are out of your hands. That's clever. Under those circumstances, yeah, I guess you could do that. Although there's going to be if there's later a question, um, the question sort of becomes, well, you knew either there was a bad address or there was some sort of a problem, right? So by doing that, did you just sort of toss that cashier's check into the bin effectively? You could certainly argue that it was okay to do, and that avoids the issue of having to send it to the state. I would be very careful about doing something like that, particularly if you have any indication that the reason that the check never got cashed was because either there's a bad address for the client's incarcerated, or something else is going on. But I guess technically you could do that. I don't know that I'd recommend it, but yeah, you could do that.
Alrighty. Greg asks, when a settlement check is made payable directly to the client, but the check is first sent to the attorney's office, can that check be forwarded to the client without involving the trust account?
Um, yeah, if it's made directly to the client, yes, you can, yeah. I mean, obviously you're going to want to, it wouldn't necessarily be in your ledger because it hasn't funneled through the account. You're going to want to make some sort of notation to prove that the check, when it came in, was in the client's name and that you sent it to the client. So, make sure you get a copy, make a copy of that check for your files, and make sure when you send it to the client, you do it, either UPS or certified mail, FedEx, something that gives you a tracking number.
Great, thank you. And let's see. Judy asks, do attorney fee liens have priority over other medical liens? Basically, once the client signs off on a settlement disbursement accounting, the attorney can take their fee even if prior to reductions there are insufficient funds to cover all medical lien holders.
Attorneys' fees are always per contract, and it's separate from other liens, right? Because the medical liens come out of the client's share. So, if you've got a situation where you've got a settlement and say the attorney is a 40% contingency, that 40% is divvied up among all of the attorneys claiming rights to attorney's fees, right? That is separate than the 60% half that went to the client, and the client, out of the client's half or portion, the medical needs come out. So yeah, it's I don't know that it would call it taking priority. It's just separate. They're separate pots of money.
Great, thank you. And then Zahar asks, how to account for client accounts when the credit card charges are subtracted from the client's money, net of credit card charges? Not too sure about that
I'm not
question.
sure what you're asking, but how to account for client account when the credit card charges are subtracted from the client's money? Um, you shouldn't be using a credit card from the IOLTA. If an individual client is using a credit card to pay you, and I'm not even sure how their charges would come out of their money, but if it's an individual issue related to a single client, you need to track all the debits and credits in their ledger. So any costs, whether it's charges of any sort, would be in their ledger. I'm not sure how that would happen though.
Okay. And let's see. Michael asks, if my firm is headquartered outside of California in New York, but as California admitted attorneys, do we need a California IOLTA account in addition to the IOLTA account we already have outside of California?
Do they do work? It depends on whether or not they do work for California attorneys, and whether they handle money. I'm sorry, whether they do work for California clients, and whether they handle money for clients in California. So that's going to be, you should follow up, either call me afterwards with my numbers on the materials, or talk to the State Bar Ethics Hotline and they can help you with that.
Alrighty. Okay.
Maker of the wallpaper, that is not wallpaper. That is a wall hanging. It's cloth. And I have no idea who made it. And I think it's a fairly traditional pattern, but thank you.
Alrighty then. I'm just going to skip to our last question then for
Sure.
Ryan Watkins. What is your opinion of self-reporting trust account issues to the bar?
Self-reporting trust account issues. I guess it would depend on what a trust account issue is. I mean, are you talking about, I mean, there's no duty to report under 6068. There's a bunch of Business and Professions Code 6068 has a bunch of a whole laundry list of things that need to be reported to the state bar and when. Trust account problems is not one of them. Um, if you're talking about like for instance, is it 8.3, 8.4, the snitch rule, where if you are aware of known violations, they're supposed to be reported. I, it would really, really depend on a case by case basis. Generally, I would say no. I would say if you've got some trust account issue and you've fixed it, I wouldn't necessarily report that to the state bar. If it kind of depends. If you've, I will say, I know we're over time. I'll just say this very quickly. I have had multiple clients who had office managers, bookkeepers who embezzled funds from the firm. I've had uh, clients whose partners have embezzled from the firm. Um, did they voluntarily report that embezzlement? No. However, you're going to want to document it, meaning police report. You're going to want to be able to show that you did something about it. You didn't just sit there and do nothing. So, police reports, hire an accountant to do an independent audit of the overall books. Do what you can, do a fresh start, open a new account with a fresh start balance to, sort of segregate or insulate the problematic client trust account from going forward. You take those, corrective steps. But I don't know that I would report it voluntarily to the state bar.
Alrighty,
Okay.
Kristen. It does look like Cynthia has one last question. Do you want to take it before we head out for today?
Yeah, I'll take this is the last one because then I got to
All
get.
right. All right,
Um,
perfect. So, all right, Cynthia, I reconcile my IOLTA accounting using a spreadsheet which mirrors all of the transactions of the bank statement. How do I document that I have reconciled? Do I write a note to the side stating each time I've completed the reconciliation?
well, if you're doing like an Excel spreadsheet, you could do a like a print screen type thing with a date and save that as a separate file and then continue using your Excel spreadsheet moving forward, right? Because it's a running spreadsheet. So at that moment in time, you either do save to print, print to save as a PDF, or you know, have a separate, maintain a separate memo that simply says like, I reconciled on such and such a date, like a running I notation that you reconciled it. But generally, if you look at my attachment to the materials, it says, you want to make a paper trail. So if you can like maybe print it old school or print and save as a PDF, that's the best way. All right.
All right. Well, that's it for today. Thank you so much, Christine, for an excellent presentation. I know our audience is already sending their praise in the Q&A too.
Thank
Right?
you.
But thank you, and thank you to our audience as well for joining us today. Have a good day, everybody.
Thanks, guys.